Beyond withdrawals and claims, which has been a big focus in the media space, there are legal implications that most people may not be aware of. Like, how will this system change the division of retirement assets during divorce? What does it mean for long-term retirement security, especially post-divorce? To help us understand the ins and outs of how pension law intersects with family law is Lisa de la Harpe, our senior legal advisor at Sanlam Corporate. Lisa has been instrumental in sharing her expertise online and in media and when needed to simplify and help us understand the legal implications of the two-pot system, especially when it comes to how it affects divorce settlements and compliance. Welcome, Lisa, and thank you for joining us so much. So let's get started. We've seen a lot of two-pot awareness content shared by you, Lisa. From a legal perspective, what are the most significant changes that the two-pot system introduces when it comes to divorce proceedings?
To put it on a high level, I think the minute you think you say something like, what did it change? People think, oh gosh, can I not claim anymore? You can still claim from it. It is still taken into account by the court when they calculate the patrimonial assets to divide. There's, at the moment, a little bit of a contradiction between the Pension Funds Amendment Act and the Divorce Act as to how you calculate that, which is creates a little bit of legal uncertainty because you could actually have differences in the calculation of the pension interest when it comes to how divorce lawyers apply it. But in essence, you can still claim from the retirement fund. In certain instances, obviously, if it's not the case of that you're entitled to claim. It depends on your marital regime, etc. But the same requirements that still apply. You have to your order has to specifically meet certain requirements. Otherwise, it's not enforceable against the fund. That's why it's so important to make sure that the lawyer that you appoint understands pension law, especially. Other than that, the impact that we didn't have before, obviously, is on the savings withdrawal, emergency savings withdrawal part. But I do think we cover that a little bit later.
Yes, actually. So what should divorcing couples be aware of when it comes to splitting of their retirement savings? Well, all the pots. I mean, we've got vested, we've got emergency and savings, and the retirement pot. Will this be equally, divided? Yes. Subject to divorce settlement?
Yes, the deduction that's going to be made will be deducted proportionally across the three.
Okay, that's good to know. And then pre-divorce, because I think there's pre, post, during. Yeah. So let's start about pre-divorce withdrawals. If one spouse decides to withdraw from the savings pot before the divorce proceedings, how could that impact the settlement process? Yeah. Will courts take pre-divorce withdrawals into account when dividing the remaining assets?
So I'm going to answer you this way. The way the Pension Funds Act is worded is a fund can only give effect and pay out the money that's actually available. So if you had a divorce order, for example, saying I sign 100,000 Rand to my ex-spouse, but at the time of the divorce being granted, you only have 80,000 in the fund can pay no more than with the actual benefit that they hold on behalf of the member. And obviously, because of the fact of in terms of the new two-pot system, members will have the right to make a withdrawal once per tax year from this emergency savings pot. The legislature envisage this situation where you can have a divorcing party with malicious intent go and make a withdrawal and at the moment the savings pot, obviously the value is still quite small. We've just kicked off with this, but in a few years it's going to be a third of your total contribution. So it does specifically, the legislation as they've amended it to cater for two-pot specifically states that if a fund is made aware of the fact that divorce proceedings have been instituted, they are not allowed to pay a savings withdrawal claim without the non-member spouse's consent. So for people in the process of getting divorced, I think it's very important to make sure that you notify the administrator of the fund of your spouse and from who you intend to claim that these divorce proceedings have been instituted so they can put a hold on the savings.
And if they don't, then that means the other member could be liable to paying while as soon as the divorce has started.
Yes, but that would be a claim that you would have against your spouse and not against the fund, because like I said, the fund can pay no more than what they actually hold.
Got it. And so now post-divorce, shifting to retirement planning, what advice would you give to individuals going through a divorce when it comes to safeguarding their future retirement securities under the two-pot system?
I think if I can give advice in the sense of, we do tend to refer to settlement quite often when we talk about divorce. And I think it's important to remember, if everybody was mature and almost want to say financially savvy, it is always the best thing to settle a divorce matter. It's very expensive. It's very long-winded. At the end of the day, the attorneys win more than most. Probably a contentious thing to say, but having practiced myself, I do know how the charge systems, if I can put it that way, practices work, and it can really be a very long, drawn-out process, which is not good for anybody involved. Is if you are in a fortunate enough position that you are entering into settlement negotiations, in the sense of there's not the intention to go to trial, I think often people tend to see this as an easy way to settle who owes what kind of a thing, because it's normally, for many people, it's their biggest asset. But you have to think about that long-term impact that has. In essence, let's say you are married in community of property, and this is one of the pension interest is one of the assets you're going to split down the half. That's half of your retirement savings. And people, tend to get divorced a little bit later in life, which means that the years you have left to make up for that payment is limited. So I think it's something that people should carefully consider, not, jump to that as that's the easy one because you don't feel the impact now.
Because there's long-term implications if you don't do a thorough, okay.
And then maybe one thing to add as well, the non-member spouse, in terms of the Pension Funds Act, they have a choice. So let's say, for example, I'm the non-member spouse and I was awarded 50% of my husband's pension interest. I have the option to take that 50% in cash or to transfer it to another approved fund. If you take it in cash, you're going to pay tax on that. And in that sense, if you transfer it to another approved fund, it's going to be tax neutral. And that is a good way to make sure for your own future retirement savings that, especially since you'll now be a single woman with one income. So those kinds of things are important to consider. Not be tempted to take that out in cash and go maybe settle debt or because you're going to pay a lot of tax.
That's very good advice. And then fund governance and compliance. So what new responsibilities will pension fund administrators have in terms of managing and enforcing divorce settlements under the two-pot system? Are there specific challenges they need to prepare for?
Well, what's completely new is the fact that you now have this restriction on savings withdrawal claims where divorce proceedings have been instituted. Previously, before you have a divorce order in place, the fund, first of all, is not going to know. And secondly, before the order is actually granted, the non-member spouse has no right to anything yet, if I can put it that way. There's now this new requirement on the obligation on the fund to suspend a savings withdrawal claim where they know that there is divorce proceedings instituted unless the non-member spouse consents. So you definitely have to make sure from an admin perspective that you have the capability to make a note, I want to say, on the member's record to make sure that you keep this in place. Similarly for maintenance orders as well.
And what about the impact on dependents and beneficiaries? How does the two-pot system affect beneficiary designations post-divorce? Are there legal guidelines or best practices for updating beneficiaries post-divorce, especially when dealing with two separate pots?
I think in that sense, it's not necessarily a two-pot change. I think it just again highlights the importance of understanding how death claims are handled by funds. Lump sum death benefits have become payable as a result of your membership. So typically you have the option to nominate a beneficiary, but I think what's different to the approved risk benefit kind of space is that the trustees are not bound by your beneficiary nomination. So it's one of the factors, one of many, that they will take into account. But at the end of the day, dependency is key. So in terms of how the act is worded, they have to identify dependents that's specifically defined, that are those that were dependent on you or would have become dependent on you. So if you have something to bear in mind is if you get divorced and in terms of the divorce order you have an obligation to pay your ex-spouse maintenance, just bear in mind the fact that you're no longer married doesn't mean that automatically you're not going to get anything from your death benefit payable when you pass away. They will still qualify as a legal dependent in terms of Section 37C. So that's just maybe something worth noting.
Okay. And will the two-pot system affect how maintenance claims are calculated in divorce proceedings, especially considering that one spouse might have access to part of their retirement savings through the savings pot?
Let's answer that on the divorce one, because that's the more complicated one. I mentioned at the outset of our chat that there's a little bit of legal uncertainty at the moment. So without going into too much detail, because I do know, I think it's only us lawyers that find it super interesting, but I've written quite a bit about this as well, is how pension interest is actually calculated is set out in the Divorce Act. So when you approach a court for a divorce order, obviously the court has to turn to the Divorce Act, to give the parameters of what are orders that the court can give. And there's how it's always been worded, and still is that it would be the benefit that the court takes into the calculation is whatever amount you would get if you resigned from employment today and your membership came to an end. So obviously we know before that would be whatever was in the fund if you were, let's say, a member of a pension fund. Now that's not the case anymore. You can't get your retirement pot. So what they did is the legislator went and amended the Pension Funds Act and inserted a new definition of pension interest that takes into account this nuance in the sense of to still keep it that you calculated according to the whole fund balance, because obviously that's the intent. The problem is that we're sitting with a situation where we're not sure how lawyers are going to apply it. They might be following the Divorce Act definition, which hasn't changed when they work out calculations and advise their clients, which means the settlement amount percentage that they help their clients come to might be less or more, depending on which definition you're going to go with. So unfortunately that it remains to be seen how the courts are going to interpret that. Then with regards to maintenance, what we have seen as a change is a new section's been added where that actually refers to future maintenance that can also be payable. However, I must tell you, there's court cases on this that the Maintenance Act does make provision for future maintenance. So I think you must just have an attorney there that really does have very good experience in the Maintenance Act and the legislative provisions there, just to make sure that you don't end up sitting with an empty order that you can't actually enforce.
Sure. I think you said a mouthful, Lisa. I've certainly learned a lot. It's not only lawyers that be interested. Trust me, this is really, really, really insightful and educational. So thank you so much for taking the time to be with us and simplify this what seems to be complicated. And it's just so interesting to note and see how Two-Pot actually affects everyone. It's not brokers. It's not only brokers and advisors and members, but it's also lawyers as well, because all of these things are intertwined. Absolutely. So thank you so much for joining us, Lisa.
You're welcome.
Well, that brings us to the end of this episode of Sanlam Corporate's In Conversation podcast edition. A big thank you to all our guests for breaking down the complexities of the Two-Pot system and sharing such valuable insights. If you have any questions or would like to explore this topic further, feel free to reach out to us or visit our website on www.sanlamonlinecorporate for more information and resources. Until next time, from me, your host, Ulitilwe Ramashala, stay informed and stay confident.